The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is State versus Leaks, and we will hear from the appellant.
May it please the court, I am Bill Spence of the Lenoir County Bar. I would like to reserve 10 minutes for rebuttal. I represent Mr. James Leaks, who was brought to trial in Mecklenburg County on a charge of first-degree murder. His defense was self-defense. Mr. Leaks testified. He said that the deceased, Mr. Darrell Curriton, came at him with a 2x4. He feared for his life and he stabbed him with the intent to get him off me and to stop him from hitting me high and low with a 2x4. The defendant testified that he did not intend to kill the deceased. At the charge conference, Mr. Leaks' attorney requested that the pattern charge 206.10 be modified pursuant to footnote 4, which is still in the pattern jury instruction, to say in effect, the defendant wanted the pattern jury instruction to say in effect that the defendant would be excused of both first and second degree murder on the grounds of self-defense if he believed it was necessary to use deadly force against the victim to save himself from death or great bodily harm. And that is opposed to the way the pattern jury instruction reads, that it was necessary to use deadly force against the victim. No, strike that. It was necessary to kill the victim. That's the way the pattern instruction reads. The defendant's lawyer didn't want that, necessary to kill, which I equate with intent to kill. The trial court refused to change the pattern instruction based on State versus Watson and then State versus Richardson. The Court of Appeals held the same way. The Court of Appeals did say that possibly a statute had come into effect that changed the both those cases, or at least State versus Richardson, but they were bound by the Supreme Court's Richardson case, really, is what they said. And my argument is simply that the jury who was sitting there in Charlotte, or Mecklenburg County, Charlotte, that the jury heard Mr. Leaks say he did not intend to kill Mr. Curriton. The judge instructed them that in order for them to find defendant not guilty of first or second degree murder on the basis of self-defense, they would have to find that defendant intended to kill Mr. Curriton or thought it was necessary to kill Mr. Curriton, which again I equate as the same thing. If the jurors are to follow the law as given to them by the judge, there is no way they could find defendant not guilty of first or second degree murder based on self-defense. If this argument has been raised and rejected before in Watson and Richardson, it was done so before NCGS 14-51.3, which is the statute that the Court of Appeals mentioned and which I am mentioning, which basically says that if a person is in a place where he has a right to be, like in the street, and he is attacked, he can use deadly or non-deadly force to protect himself from death or great bodily harm.
So let me make sure that I understand where the lines are drawn in this case. Was the instruction at issue which the trial court gave an erroneous instruction?
Under the facts of this case, yes.
how was it erroneous as an approved instruction in the pattern jury instructions?
Well, the pattern jury instruction has a footnote 4 that indicates you can change that around if the facts of the case require it. And that's what I'm arguing, that the facts of this case require it. There was never an intent to kill the man.
So you're saying that the trial court was required to modify the approved pattern jury instruction here?
Yes. And the reason is the trial judge is required to give an accurate jury instruction that is in tune with the law. And if he fails to do that, then he's not done the right thing.
Thank you.
Mr. Spence, to follow up some on Justice Morgan's questions, he referred several times to an approved instruction. I mean, what I've been looking at is this court's decision in Richardson, which seems to me to have said, in effect, that there is no difference between an instruction that requires the proof that the defendant believed that it was necessary to kill the victim, as compared to an instruction that said that it was necessary for the defendant to use defensive force. And at least as I read the court's decision in Richardson, it holds that the two are synonymous, and therefore there is no need for the additional instruction that your client requested in this case, and in fact disapproved the language from State versus Watson that the footnote 4 in the pattern instruction refers to. In light of the fact that Richardson seems to me to, at least rightly or wrongly, to address the decision that we've got before us, why is that decision not controlling in this case?
I tend to agree with, and I can't think, Professor
Rubin?
Sir?
Professor Rubin?
Yeah, Professor Rubin. He said in some of his language that Richardson requires a close reading. Maybe I'm reading into what he said about a close reading. I don't know that I could follow Richardson. I'll tell you the honest truth. I know what it said, but the logic and the reasoning in it, I could not follow. I'm sorry. But
Are you
question?
Do you disagree that Richardson, at the end of the analysis, and I've reread it today too, and I would not disagree with you that it's a complicated opinion. At the end of the day, though, what are we supposed to do with Richardson, given that it's there?
Well, what I'm arguing is that the statute 14-53.1 at least modified Richardson in that it says if you're in a place where you've got to be, you can use you can use deadly force or non-deadly force. And I don't know that the law was, well, Ms. Babb, I guess will speak to that, but I don't know if that was the law at the time Richardson was decided. But it's for sure it's a statutory law now.
Well, Richardson, at least as I read it several times, refers to the fact that a defendant is entitled to one of the components of what a defendant has to show in order to be entitled to exercise the right of self-defense using deadly force, is that the defendant has to show that a reasonable belief that it was necessary to either kill or use, or necessary to prevent death or great bodily injury. And that language seems to me to be somewhat similar to the language that appears in GS 14-51.3A1. And so I guess my ultimate question is, what about the language of the statute should cause us to think that the instruction that was at issue at Richardson isn't sufficient now.
Well, the only problem is you got 12 people sitting on the jury, and they hadn't read Richardson. They don't know what the law is, and they've heard the defendant testify that he did not intend to kill the man. And then the trial judge sits up there and instructs the jury and says, look, in order to find him not guilty of first or second degree murder on the basis of self-defense, you've got to find that he intended to kill him. And there's no way in the world a jury, if the jury follows the instructions given to them, is going to do anything other than what they did, find him guilty of either first or second degree murder. And they picked second. And that's essentially my argument is basically jury oriented. I just don't see how the jury could do anything other than what they did in light of the charge given to them by the trial court. And I think under the facts and of this case, that instruction was not correct. If the judge had given a correct instruction, which I'm contending that he didn't do, then it would have been up to the jury what to do under a correct set of instructions. And there's an issue of prejudice. Was he prejudiced? And my argument to that is, yes, he was prejudiced because the jury was faced with no other. They couldn't find self-defense under the instructions. That's basically my argument.
If I can make sure I understand what you're saying about the way in which the statute is inconsistent with the jury instruction as it was given in this case, are you saying that if 14-51.3A1 said instead that a person is justified in the use of deadly force if he or she reasonably believes that it's necessary to kill another person in order to prevent imminent death or great bodily harm, that would then be consistent with the jury instruction?
That probably would.
Right. But that's not.
But as I understand that statute, as I read it, you can use deadly force or non-deadly force if you're in that situation.
And it's your contention that there's a difference between believing that it's necessary to use deadly force and believing that it's necessary to kill someone.
Well, I hadn't thought of it that way, but I don't. But my main thrust is what does the jury think? If the jury's sitting there and they've heard him say, I didn't mean to do it. I didn't mean to kill him. And the judge says, well, you can't find him not guilty on self-defense unless he meant to do it, unless he meant to kill him. There's an inconsistency there. And that would be my argument.
Counsel, I assume you want to reserve the balance of your time for rebuttal.
Yes, sir.
Thank you. We'll hear from the appellee.
Good morning, and may it please the court. I'm Mary Carla Babb with the North Carolina Department of Justice here on behalf of the state. Your Honors, in this case, the Court of Appeals did not err in rejecting defendant's challenge to the trial court's jury instruction. I think what is important here is exactly what defendant is arguing, and I think he's clarified that to some degree in this court and this argument. Defendant is making the exact same argument that the defendant in Richardson made, and that was rejected. And with that, defendant has not articulated and has not answered the question, what about the language of the statute would make it different such that Richardson, is no longer good law? And defendant is arguing that necessary to kill is equated with and injects, a specific intent to kill requirement for self-defense. And if you read Richardson, it doesn't even require a close reading of Richardson, but if you read it, the court rejected that argument. It firmly did so. It noted that plea of self, and I'm reading from the case, a plea of self-defense is a plea of confession and avoidance. And by it, defendant admits that he intentionally, in that case, shot, here it's stabbed, the assailant in the chest, but he did so justifiably to protect himself from death or great bodily harm. And a killing in self-defense is an admitted intentional act, as is second-degree murder. Same thing here. Simply because the defendant admits intentionally committing an act resulting in death does not mean he admitted forming the specific intent to kill. So Richardson rejects the notion that with self-defense, the court has put in there a specific intent to kill requirement, and it also rejected the same argument defendant is making here, that to ask the jury to consider whether a defendant reasonably believed it necessary to kill the victim to prevent death or great bodily harm, that particular phrase meant that it was asking the jury to consider whether the defendant had the specific intent to kill. So this particular argument.
To pick up on Mr. Spence's argument a second, let's assume, let's you and me divest ourselves of our law degrees for a second and put ourselves in the position of a reasonable juror for a second. You are instructed that in order to acquit a defendant on the basis of self-defense, and I'm going to reverse the burden of proof because it's just easier to say it this way. I think we all do this sometimes. And I'm just reading straight out of the instruction that was given in Richardson. Appeared to defendant and he believed it to be necessary to kill in order to avoid. If you hear that and you have evidence that the defendant said, no, I didn't believe it was necessary to kill, but I reasonably believed that it was, I was about to suffer great bodily injury and I needed to take action using deadly force to prevent myself from being killed or suffering great bodily injury. What would you do with that defense? Is it your contention that a reasonable juror would assume that, as Richardson does, that an intent to kill and that a belief that you need to kill and a belief that you need to use deadly force are the same?
No, Your Honor, because like with all jury instructions, you need to read it, the complete instruction. So you're examining.
So what other part of the instruction would tell the reasonable juror that Mr. Spence's concern is not well founded?
Well, I point the court to this court's own decision in Richardson, the way it interpreted.
Right. I'm just trying to look at the language of the instruction. I mean, you said I've read Richardson, but and understand what it holds. It holds that there's some, the two are synonymous essentially. What I'm trying to determine is what's the basis for believing that the two are synonymous? Taken in the abstract and without the analysis in Richardson.
I think that Richardson, sort of a subtext, is concluding that they're synonymous. But I think that what Richardson is really saying is this particular part of the self-defense test is in no way, it's not about the instrumentality or the method used that resulted in the death. That's irrelevant. What it's trying to do with this particular element is getting at what defendant's belief was. And necessary to kill in that context does not mean specific intent to kill. I mean, the jury is going to be instructed on that. If obviously if it's a first-degree murder case, it will be instructed on what that specifically means. And necessary to kill.
This is a second-degree murder case, I think, at this point, where we've got
Well, here the jury was instructed on both first
Right.
and second degree murder.
Right.
But in this context and in the context of what this particular element is trying to get at and what it's trying to tell the jury to focus on, necessary to kill is not equated with the specific intent to kill. If you know, Richardson doesn't come right out and say this, but it from its context and the way you read it, it's necessary to kill it means necessary to perform an intentional act against the person of the victim that resulted in the death. And so here, necessary to kill, if someone believes it's necessary to kill they don't have to necessarily have a specific intent to kill. They don't necessarily have to have a want that the victim die. That is not the meaning of that phrase. They are distinct. And defendant is asking the court to reinterpret Richardson, which it has declined to do for the past 25 years, and reinterpret it based upon the exact same arguments that have been made to ask the court to reinterpret it for the past 25 years. So that phrase.
Ms. Babb, I hate to interrupt you when you're in full flood here, but I think the argument that Mr. Spence is making, and had already had some conversation with him about this, is I think his contention is that the adoption of the statute works a change in the law in some respect, so that Richardson is no longer applicable. I know you don't agree with that. Would you tell me why?
Well, what I don't, the answer to the question I don't hear is, how is it different? You know, if it is different, point to something that shows that it's different, that it means Richardson is different after the statute, and there is nothing here to show that. And defendant has not pointed to anything, and when you examine the statute, it is on all fours with our common law on self-defense. Every part of it talks about the non-deadly, deadly force dichotomy, indicating that you need to have this belief that you're about to be met with imminent death or great bodily injury, and that it has the no duty to retreat, which has been part of North Carolina law. There's been some confusion about that, but that's been part of North Carolina law. So it's exactly the same as the common law. So there would be the statute doesn't give cause to re-examine the state's, this court's law. Also, Mr.
Yes, if I can just ask you a question about that point. If the statute doesn't say that in order to be entitled to self-defense, you have to have a belief that it's necessary to kill, if the statute itself doesn't say that, why isn't the defendant in this case entitled to an instruction that tracks the language of the statute, independently of whether or not we agree that necessary to kill doesn't mean specific intent, and that intent to use deadly force is equivalent to intent to kill, that you believe it's necessary to kill? Regardless of how we resolve those, if the statute itself does not use the language, you must believe it's necessary to kill, why isn't the defendant in this case entitled to an instruction that tracks the language of the statute?
So the defendant, what you're asking is, and I just want to clarify, Your Honor, if you don't mind. So defendant would be entitled to an instruction that under the statute that has the 4 parts, and that just switching out the word kill with deadly force. Is that?
Well, essentially, I'm saying, why isn't he entitled to the instruction he asked for?
Well, that is the instruction he asked for. All he asked was to switch that out.
Right.
So that would, the court would have to agree with everything, and you've said that the court would have to agree with everything else defendant is arguing, in that this court has previously read a specific intent to kill element into self-defense, that the phrase has that specific intent to kill in there, and that the statute no longer requires that, and requires, what it says. I don't think just switching out from the 4-part test the deadly force for a kill is not going to be a reflection of the law, because you're going to have you still have the four-part test, and you're still going to have the confusion that the court in Richardson spoke of between 2 and 4. It seems to me that so that's not what defendant asked for. Defendant didn't ask for a instruction that was on all fours with the statute. In fact, defendant didn't assert the defense of the statute that he's alleging now exists. So I don't think just switching it out on the pre-existing test would be an instruction in line with the statute, because you would still have those problems you would have in Richardson. The court would have to come up with something new. This defendant would have to ask for something new under the test, which he didn't. And a court doesn't err when it refuses to give an instruction that's not supported by the law. And I think the four-part test, just switching those out, switching out kill with deadly force, doesn't get you there.
Is the pattern jury instruction that was given by the trial court in this case consistent with the statute?
Yeah, yes, Your Honor. It's the state's contention that it's consistent with the statute. And just to clarify, the statute says the base common law, much like some of the early decisions from this court, which is like the basic common law of self-defense. It's stated there in the statute. Now, what the court did was take that basic common law and come up with this elemental test that covers it, because it determined that it wanted to put the qualifier of excessive force in there to distinguish it between perfect self-defense and imperfect self-defense. And so that elemental test is developed from what the basic common law is. So the basic common law is reflected in the statute, and therefore this elemental test is still good law, and that's what's reflected in the jury instruction.
Is the instruction that the defendant requested in this case, which was not given, in favor of the trial court's determination that the approved one would in fact be given? Were they both eligible to be given, and the trial court just chose to give the one that was approved?
Well, he did choose to give the one that was approved. And the one that was approved is the one that this court in Richardson approved. So that's the one that should be given. The defendant wanted a modification based upon a footnote that remains in the jury instruction. It looks like the pattern jury instruction, it looks like it's there inadvertently, because the court in Richardson would disavow that as a proper change to the elemental test. So to answer your question, the instruction, the pattern jury instruction is the law. It is the correct law, not switching it out with what was suggested in Watson, which this court disavowed.
So is it, I'm sorry, go ahead, Justice Morgan.
No, please, I've spoken enough. Thank you.
I just had one question. Is it the state's position that it just in regular ordinary usage, saying to the jury that the defendant has to believe it was necessary to kill is the same thing, means the same thing as telling them that the defendant has to believe it's necessary to use deadly force?
Yes, Your Honor. At least it's pretty close. So the language of what this court has defined as deadly force is force intended or likely to cause death or great bodily harm. And there's no definition specifically of great bodily harm, but serious bodily injury is injury creating a substantial risk of death or a list of other injuries that could be considered serious bodily injury. And so for those things to be different, for a jury instruction that says defendant must believe that it's necessary to kill to prevent death or great bodily harm versus the jury instruction that says defendant must believe it's necessary to use deadly force to prevent death or great bodily harm, there would be, at least in the context of murder, circumstances would have to exist such that a defendant could believe it was necessary to use a method of force that he intended or would know is likely to cause death or great bodily harm, and simultaneously believe that that predictable result from the force would somehow not kill the attacker. That seems impossible.
Let me ask you in the terms that Mr. Spence put it, that if the jury is instructed that they had to believe that the defendant intended to kill the victim, and they heard the defendant say he did not intend to kill the victim, so that the effect of that instruction was to have the jury think they had no choice but to find him guilty, why wouldn't he be entitled to an instruction that gave the jury a choice?
Well, the jury, just to clarify, the jury was not instructed that he had to specifically intend the death. The jury was instructed that defendant has to believe it's necessary to kill to prevent death or great bodily injury. And so so the instruction was not, the jury must say that he specifically intended to kill. And this court in Richardson's and the state's position is it's still good law, even after the statute, because there's no change, has said that that phrase does not graft upon the test a specific intent to kill. So he,
well, I guess when you answered my question about whether the language for the two phrases necessary to kill, necessary to use deadly force means the same thing, you said it was pretty close. And my question about that is if the defendant is staring down a verdict of murder as opposed to not guilty, maybe, or something lesser, why isn't he entitled to exactly the words that he is asking for?
Well, this court has said that he's not entitled to exactly what he's asking for. He's entitled to something. He doesn't necessarily get exactly what he's asking for. He can get what he's asking for in substance. And
right, so I guess that's the question, is whether those two phrases are in substance the same when there's a statute that incorporates the essence of the language that the defendant requested.
Well, so you have to look at what is the law, the elemental test. The elemental test incorporates all of those components of that statute that were the components under the common law. And element 2 is trying to get at what the defendant is excuse me, I'm sorry, I'm mumbling my words, is trying to get the jury to focus on what defendant's belief is, whereas element 4 is about excessive force, the instrumentality, and the type of force. So the elemental test embodies what is in the statute as it has embodied the common law. And he's, as long as the judge gives his requested instruction in substance, which is what happened here, then there was no error on the part of the judge in instructing the jury.
I want to make sure I understand what I think I heard you say. I thought I heard you say to Justice Morgan that an instruction in the form that the defendant asked for would not be proper. So an instruction that said he had to believe it was necessary to use deadly force would not be proper, but the one that was given was proper. And yet you're saying that those two things are the same, or at least the same in substance. So why would the instruction that the defendant asked for not be proper if those two phrases are essentially the same?
Well, I guess I should clarify that, and I understand that now that you're saying that's what Justice Morgan was asking for. Is that was the pattern instruction, and that's what the judge chose to give. It was the instruction that has been approved by this court in Richardson. And in all of these cases where the defendants have asked that the court re-examine Richardson, they have all asked for the same thing, and that is to switch those two things out and it has been rejected by this court.
With regard to the Richardson opinion itself, and you've alluded to what the Richardson court sets out as the four-part analysis in the opinion. The first and second, first being it appeared to defendant and he believed it to be necessary to kill the deceased in order to save himself from death or great bodily harm. The second, defendant's belief was reasonable and that the circumstances as they appeared to him at that time were sufficient to create such a belief in the mind of a person of ordinary firmness. The court says the first and second elements of self-defense require consideration of whether the victim did something to create a reasonable fear of imminent danger in the mind of a person of ordinary firmness. Help me better understand what the court's saying with that. The focus there is on the creation of the risk or the danger such that, I mean, clearly the backdrop is you have a victim who's been killed. You have a defendant, by raising this defense, says, yes, I killed him, but I was justified in doing it. So help me understand what the first and second elements is described in Richardson, what that focus needs to be.
Well, the focus, according to the court in Richardson, needs to be the belief by the defendant, and certainly the victim's actions can be evidence of that belief, and you know whether the defendant's belief, what it was, and whether it was reasonable. So the focus of those two elements is the belief of the defendant.
And what's the difference? I think you will say there's none, but use deadly force, okay? Deadly means somebody's dead versus necessary to kill. How are those? Help me just kind of work through how deadly force is sufficiently similar. I think that's your argument, to necessary to kill.
Well, you just have to look at the definition of deadly force, which is force intended or likely to cause death or great bodily harm, and necessary to kill. I mean, the example is this. The example this case presents shows how similar they are. I mean, you have a situation where defendant admits stabbing the victim in the chest, and the uncontroverted physical evidence was that he stabbed him such that he broke a rib, he caused 3 perforations to the defendant's lung, and a large gaping hole to his heart caused a highly lethal wound. So for there to be a difference and for a defendant to have a different belief based upon both those phrases, he would have to believe it was not necessary to kill the victim, but it was necessary to intentionally stab him in the manner that caused a highly lethal wound. So I think that demonstrates that they are the same or substantially the same. And even if the court were to conclude they're not synonymous, I think that they're similar enough such that with other factors, defendant was not prejudiced by the giving of the instruction that he got here, even if the court determines that he should have gotten one that reads necessary to use deadly force. I want to first point out that defendant did get a self-defense instruction here. This is not a case where the defendant didn't get one at all.
So Ms. Babb, just to make sure I'm following you, are you at this point transitioning from an argument that there was no instructional error to an argument that says if there was one, it was non-prejudicial on the facts of this case?
Yes, Your Honor. I'm sorry. I did make that
No, I mean,
clear.
I'm just trying to make sure I'm following you. Sorry.
Yes. So in this case, there wasn't a reasonable possibility of a different result here. The first thing the court should look at is that this defendant actually did get a self-defense instruction. He got one that has worked for, I don't know, 70, 80 years in our jurisprudence. And it's not a case where the court erred in just not giving a self-defense instruction, or where the court erred and not giving what this court has concluded is a fundamental part of a self-defense instruction, like with the no duty to retreat cases. Here he got an instruction on self-defense. It was a complete instruction. It's just, we're just arguing about one phrase. Also, for the reasons previously argued, they have pretty, if not synonymous, substantially similar, close meaning. And finally, as noted in the brief, the uncontroverted physical evidence here makes defendants claim about, that he just intended to disable the victim. That's his reading of his own testimony. It makes that impossibility. As noted, the evidence here was that he stabbed him with enough force to fracture his rib, put 3 holes in his lung, and a large gaping hole in his heart. The testimony from the doctor that performed the autopsy was that the knife went in and came out, and it came out at least twice. So he stabbed him between 2 and 3 times, that he put the knife in and pulled it out at least 2 times. So 2 to 3 times. The doctor who performed the autopsy, Dr. Privet, characterized the wound as a highly lethal wound. So on this evidence, defendant's version of events is impossible. And there's no way the jury would have concluded that on his version of the events that he was acting in self-defense, and reached a different verdict. I also want to, I understand, and of course the state understands, that credibility is a determination for the jury. However, the 2 impartial and interested bystanders testified that at no point did they see the victim attack the defendant, that he was always holding the piece of wood, the 2x4, by the ends up, trying to fend off the jabbing motions, plural, of the defendant. And the testimony that there was more than one motion, that there was motions plural, coincides with the physical evidence that the knife was pulled out at least 1, if not 2 times. It's worth mentioning, defendant didn't, the testimony he gave was not similar to the testimony that he gave police in regards to saying he was in fear of his life. He never said that to the police officers. And finally, defendant claimed that he was hit severely the entire time the victim was hitting him during this encounter, and his wounds were described at trial as being no more than superficial or minor. So for all these reasons, there was no reversible error in the jury instruction in this particular case, and the state asks that you affirm the decision of the North Carolina Court of Appeals. Thank you.
Thank you. Rebuttal.
Your Honor, just briefly, I think the average juror would think deadly force is using a gun or a knife, but not necessarily to kill somebody. Using deadly force to get him off of him, to prevent him from coming at him with a 2x4. Well, I shouldn't say it, but I'm going to say it anyway. The movie Amadeus, where the king tells Mozart that he's got too many notes in his composition. Richardson, every time I read it, that's all I could think about. I think it's got too many words. I just could not follow it. And my basic argument is how it's going to affect the jury, how this jury was affected by what was done. And I think it could have been correctly done differently. And I think that pattern jury instruction, that footnote number 4, is still there for this situation. It's been there for years and years. It's been there for a long time. That's my argument. That's my rebuttal. Thank you.
Thank you, counsel. Thank you to both counsel, Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.